Hello and welcome to our Spotlight video series where we discuss cutting edge employment law issues in the news. My name is Tom Spiggle. I am founder of the Spiggle Law Firm, where we help people who have been fired or afraid that they might be. Thrilled today to be joined by Stephen Anderson, an attorney in my office. Welcome, Stephen.
Good morning, Tom.
All right, so I think we're going to talk about the Supreme Court case involving the wedding cake designer and its impact on employment law. So I will let you jump in.
Yeah, so on Friday, the Supreme Court, in the 303 Creative LLC case, said that a website graphic designer who was a Christian woman did not have to make websites for, I believe it was a gay marriage. So their experts are speculating this will have reverberations in the employment context in terms of employers being able to use the expressive nature of the First Amendment to shield themselves from either hiring or promoting employees.
Yeah, no, and just to kind of lay the groundwork, usually, under public accommodations law, which is where this falls under, if you're a business owner and you have a hotel or a restaurant, or in this case a graphic designer, if you're and she was in Colorado, holding yourself out for business for the public, you can't discriminate on the basis of a protected status, in this case, sexual orientation. And her argument was, well, the government can't compel me to engage in speech that I don't agree with. And the Supreme Court sided with her. This was not of itself an issue about same-sex marriage or LGBTQ rights. The court framed it as a free speech issue. So the issue is, as with many of these groundbreaking cases, we saw another one on affirmative action last week, there will be spillovers into the employment law context. So what sort of things are you looking at, Stephen?
Yeah, so they're looking at this in conjunction with other cases. I mean, the Supreme Court 3 years ago in Bostock versus Clayton County said that employers can't discriminate against applicants on the basis of their gender orientation or gender identity. However, in 2000, there was the Boy Scouts of America case where they were Boy Scouts of America was allowed to prohibit gay employees from serving as scout leaders. Since that was technically a leadership role rather than, allowing someone to be employed at all, that was allowed. And then also recently, there was a Second Circuit panel in February that allowed an anti-abortion pregnancy clinic to not employ individuals who had undergone abortions on the basis of their First Amendment right to expressive association. And so a lot of commentators are just concerned that since this case, basically, there's dispute as to what specifically, the services, the scope of the services that were engaged. Whether is this preventing, gay people from being able to engage in these services, or is this preventing just gay people from engaging in receiving specific performance of services rather than receiving customers at all? But nonetheless, whatever the answer is, it'll likely have spillover and what employers will be able to do with their employees and how they'll be able to, use them in certain roles, promote, perhaps hire them, and that'll be coming down the pipeline.
Yeah, I think it's a great point. There has long been a balancing test that courts have applied when an employee's right to, religious expression, let's say a holiday, or they want to wear a certain hairstyle consistent with their religious beliefs. Where is the line where an employer can take action against them? Let's say, and have a dress code, or have a disallow them from taking time off on one of their their religious holidays. And now, I mean, I guess the question is, how will this case affect that balancing test? Are we moving more towards, employees having greater freedom to express themselves in the workplace, even if that might butt up against workplace restrictions? So we'll see, right? And the way that often works with these big Supreme Court cases is there will be other cases that are brought up through the lower courts, right? We don't all get to go straight to the Supreme Court.
Mhm.
And the lower courts are going to have to struggle with this and decide, what the parameters of the decision, what it means for employment law context. And so I'm sure we're going to see this litigation. Some of these cases will eventually percolate back up to the Supreme Court and give the court some, opportunity to clarify or refine, how these might play out in the workplace. But it's a big decision. It's the first time that we have seen, from the court upholding this sort of kind of carve out to public accommodations laws, and the argument made by the graphic designer and the people who submitted briefs on her behalf is like, look, a gay person can still come and get graphic design services from this business. It's not preventing them from using the service. You just can't, you can't make me say, have a message that is, pro gay marriage when, as in her case, she didn't, her religious beliefs were not consistent with that. So we'll see. To be decided as to how this will play out in the workplace. But I think you're right, Stephen. It's gonna have implications, and we're gonna see this pop up more and more as other employees in the workplace context. Because remember, this was not an employment law context, but in employment law context, you're going to say, you are impinging upon my right to free expression under the First Amendment, and what courts do with that, and whether they import some of the logic from this decision. So, fascinating topic. Thanks for bringing it up, and I'll let you get back to the next thing on your desk.
All right, thanks.
All right, Stephen, take care. Bye-bye.
You too.